All I showed was proof that the truck was insured,
No, you,
registered.
all right, I'm not gonna deal with it. All right, let's set a trial date. Set a trial date.
I'm trying to get this dismissed. This is
Well,
this
it's
is
not going to
literally
be
holding me
dismissed.
back right now.
You get it
Oh God.
dismissed on the date of trial. Date of trial.
Wow. Nice. Thanks for not. Thanks for. No, I see clear as day why I'm not getting the same courtesy. Your name is Sean Perkins. Yeah. Okay. I will.
That's the last time I checked.
Yeah. Okay. I get it. It's all.
Mr. Gubin.
I don't need to hear it. I don't need to hear the blabby blab. Just stop talking to me.
I was just gonna ask, did you want to go in a breakout room?
What is a breakout room? I showed all my proof. I showed all the proof. I showed the proof, Mr. Sean Perkins. What is it? Is it my, what is it? My complexion?
Have a good day, Mr. Have a good
it's
day,
my
Mr.
complexion, isn't it, buddy?
Have a good day, Mr.
Mr. Uneducated Judge.
Have a good day, Mr. Gubin. You keep on talking.
How are you even a judge?
I'm gonna hold you in contempt, okay? And we're gonna give you some jail time, okay?
What a clown.
You done?
Anything else?
Are you
Anything
done?
else, pal?
All right. I'm gonna hold him in contempt. I'm going to give him 30 days Wayne County Jail.
Wow. This courtroom went from calm to chaos in seconds. You can literally feel the tension. The defendant completely loses control, accusing the judge of bias, interrupting non-stop and then dropping that line. It's my complexion, isn't it? That's where everything crosses the line. The judge tries to stay composed. But once you call a judge uneducated and refuse to stop, there's only one direction this goes: contempt of court. And yes, 30 days in jail. That's what happens when anger replaces reason in front of the bench.
And who are you here on?
I am here on Joshua Gubin.
All right. He has not showed. He needs. I told him to be here in person today, and he has not showed. Not neither. Oh, I think he is here. He is here. Okay, so here's the deal. It's nothing really to talk about with Mr. Gubin. I told him to come in. I said I gave him 30-day Wayne County Jail for contempt last year. I see him hold up a child. His child, he didn't come down. So again, he continues to defy orders of the court, and we just don't have much to talk about.
Well, Judge, I understand that may be the court's position as it relates to this matter. May I have just 1 second? I apologize, Judge. I needed to plug my computer in. So I understand that may be the court's position. I just got retained on this matter this morning. I was not present at the hearing where you apparently held him in contempt. He obviously has an opportunity to prepare and present a defense to the allegation. I'm not sure if the court made a finding as to whether or not this was civil or criminal contempt, and further, whether the court actually determined whether it was direct or indirect contempt. Obviously, the court's ability to sanction an individual, especially with a deferred sanction.
Things take a surprising turn. We're not even done processing the meltdown when another defendant's case begins. But the same judge, calm, methodical, is still presiding. This shows how routine courtroom chaos can be. Judges move from one heated case straight into another as if nothing happened. Imagine the emotional discipline that takes.
Well, the contempt was right on the record on the record, and I do have you can get the record for that. It was I did hold him in criminal contempt. That's why I told him 30 days Wayne County Jail. And from my understanding of the court rules, he had his opportunity to contest that. That ship has long sailed, from my understanding of the court rules, because this was done over a year ago. And the only reason that Mr. Gubin has come back before me is because he got some other cases. He let the tickets go on the warrant status. He only is before me because he got the other cases. So I still need his presence here. I'm going to readjust his bond now.
Your
He
Honor.
hasn't shared. So he continued, I've let you speak, Counselor, and I'll let you do what you need to do as far as your job, but I'm going to do my job. And Mr. Gubin continues to defy the court's orders, and we'll talk about bond right now. City of Detroit versus Joshua Gubin. Case number is SP 1411448. Count 1 and count 2. SP 1669671. Appearance for the record, please.
Yes, good morning, Camilla Barkovic, appearing on behalf of the defendant who is present.
Your Honor, Rami Hijazi, P82830, on behalf of defendant as well, Your Honor.
Okay, so you can make the record now as far as what you want to do, either counsels if you want to, as far as Mr. Gubin is concerned. Today, we'll call the date and time. There's 2 warrants out for Mr. Gubin's arrest. Let me see what the action was the last time. Mr. Hijazi was here last week when he appeared on Mr. Gubin's behalf after Mr. Gubin showed up, and I realized that he was the gentleman that was just very, very contemptuous on that day that he was here last year. The allegations were made on December the 7th, 2022. Mr. Gubin was arraigned on those matters.
Here the judge makes something very clear. Contempt isn't just a word, it's a legal mechanism. When someone disrespects the authority of the court, it's not personal, it's about protecting the system's integrity. The judge saying that ship has long sailed perfectly sums it up. Once a contempt ruling is entered, it's nearly impossible to undo unless appealed immediately.
Go ahead and make record and speak to bond.
Thank you, Judge. I've already articulated some of this to the court off the record, but I was just retained to represent Mr. Gubin in this matter this morning. I am asking for an adjournment of today's hearing so that I may obtain a copy of the transcript of the hearing that was held where you apparently held Mr. Gubin in contempt. He does have a right to counsel in any contempt situation. In addition, he does have a due process right to obtain an accurate transcript of the hearing. I would like to obviously obtain all relevant information and then address this matter appropriately. I'm asking that you take no action today and give me the opportunity that I am requesting on behalf of my client. And if you'd like me to transition into the bond issue, I am happy to do that as well.
I'll let you go ahead with bond.
Thank you. Your Honor, it is my understanding that mere traffic matters are pending before the court, at least one civil infraction, and I believe a no insurance misdemeanor. These incidents date back to 2022 based on my review of the Register of Actions. He has appeared in connection with this matter, which the court has noted. Apparently, he was here last week, and you may have recognized him. But the point of the matter is, I've known Mr. Gubin for a while. He always appears as required and as instructed. I understand that the court may have a difference of opinion as it relates to that, but I would attest to that. He is a lifelong Michigan resident. He has extremely strong family support. He is a father. He has minor children, actually, one of which is visible on the Zoom as we currently see.
Listen to this attorney. Calm, professional, logical, total contrast to the chaos we saw earlier. This is how you fight in court with facts, not feelings. He's doing exactly what good counsel does, protecting rights, ensuring due process, and reminding the court that even contempt defendants deserve fairness.
Conviction of the only misdemeanor with which he presently stands charged. His maximum sentencing exposure is minimal. He is obviously presumed innocent at this point in time. And for all of those reasons, Judge, in addition to other reasons, such as his lack of any significant or substantial criminal history, which is a factor that the court shall consider when it sets bond, I believe a personal is warranted. And retaliation for...
This part hits different. The lawyer humanizes his client, father, business owner, lifelong resident. It's a reminder that defendants are people, not just case numbers. You can see the defense trying to shift the judge's perception from rule breaker to responsible man with a family. Clip 6.
Very well. Bond is going to be set at $2,500 cash. I still, the order of Mr. Gubin still showing up because despite what you've articulated on the record, Ms. Rockowitz, I we put the warrant out for Mr. Gubin's arrest a long time ago. He was supposed to be in person here today. He's not. He also has an assault and battery case that he has a warrant out for his arrest for as well. So he showed the court and demonstrated to the court that he has not only with this court, but with the other courts and other judges in this courthouse that he has a failure to appear or something. So bond is $2,500 cash, and it's still ordered that Mr. Gubin show up in person to the court for the conviction hearing, and we will address and you can appeal the matter to a higher authority if that's what your client chooses to do.
So, Your Honor, I have a comment as it relates to a cash bond. I'm asking that the court impose a cash or surety bond. My interpretation of the court rules as it relates to bond and statutory authority allow the defendant to elect whether he posts a surety or posts a cash bond. And my position is the court cannot outright prohibit a surety. So I'd ask for the addition of a surety provision.
The court has made its ruling, Counselor. You can take it to a higher authority.
Thank you.
And finally, the judge rules $2,500 cash bond, no shy option. Firm, unmoved. This is where the courtroom reality kicks in. Judges balance mercy with control. After repeated defiance and missed appearances, leniency runs out. At the end of the day, this isn't about power. It's about maintaining respect for the law. One defendant's meltdown got him jailed on the spot. Another's composed defense still couldn't change the outcome. Two cases, same courtroom, one message.